If you have any questions during this presentation, you can type them in the chat box on your Zoom control panel, and we will do a Q&A at the end of the presentation. I'll now pass it over to our brokers, starting with Tom. Good morning, Tom.
Good morning, Tori. Hope everything's going well for you as well as everyone else here. I labeled today's Broker Accelerator do's and don'ts. Probably a better title might have been, dot your I's and cross your T's. We're starting the second half of 2019, which sounds incredible in and of itself. But I just wanted to kind of review today with Jeff some of the items that we see reoccurring throughout the first half of this year, and just kind of talk about them and mention them so that in hopes of those of you that are here, even though it may not pertain to you in terms of a specific act, it'll kind of just jar your memory a little bit to say, oh yeah, I need to do that or I shouldn't do that. So that's really the intent of today's Broker Accelerator. And so I'm going to start out today and just remind everybody to please, when you're filling out the Sky Slope file, make sure you complete in its entirety the commission tab. We can't approve the file without that commission tab being completed in its entirety, primarily because we don't know what to pay. If it's not completed in its entirety, we have no idea who to pay what, and what money should, more importantly, come to you, our agent. So, fill it out all the way down, including the disbursement section, so that we know exactly what your thoughts are. We can take a look at the paperwork to make sure all is together and move forward from there to the closing. So I would request that, again, all of you just please check that commission tab, make sure it's completed. A reoccurring issue I'm finding on my file reviews is the broker or agent DRE numbers are not always completed in the RPA, or on the last page of the residential listing agreement. So please make sure you put in the proper DRE numbers for the two brokerages as well as the two agents involved in the transaction. We can't approve the file without that being completed because it's not a completed RPA. So please remember that and take care of that. Another issue which I'm seeing that I have concern about, in essence, because I have a hearing coming up on it towards the end of this year. When you're in conversation with your clients, whether it's a buyer or seller, be careful on what you're saying. Don't offer legal opinions. Don't offer tax opinions. Don't offer construction input. Don't give construction input. We're not contractors. We're not attorneys, and we're not tax people. We're not CPAs. And the wrong advice or the wrong comment can create a big problem, not only for you, but for the brokerage in terms of your presentation and what you said and didn't say. So, if a client asks you, what do you think about, this house? Is it structurally safe? Just say, well, that's why we have inspections. We need to get people in here who are licensed and know about construction. I'm a real estate agent. I'm not a contractor. And don't be afraid to say that. I mean, we got to draw boundaries and make sure we don't cross those boundaries as agents. Our whole motivation in doing this business is we try to thrive and pride ourselves on customer service. There comes a point where that can become a problem. If you say too much, offer too many opinions. The only opinion we should be offering, one would be to, that's a great question. You need to get with a contractor, or you need to get with your CPA, or you need to get with your attorney to get a more accurate answer on how it pertains to you. We don't know our buyers and our sellers' personal situation, finances, legality, status, whatever. And so the only people that can really address them from a knowledgeable point of view would be their attorney or would be their CPA. So the rule of thumb there, do not overstate. If you don't know the answer, just state that. Also, please make sure if you have a buyer and they're looking at a house and they're saying, hey, I question whether that room addition has been given with a permit or not. Don't you, as an agent, go down to the city planning department to determine whether or not permits have been pulled on any improvements or room additions to a home your buyer might be looking at. Make your buyer go down. This is supposed to be a buyer investigation, not an agent investigation. The problem with you going down alone is, one, you might misinterpret what the employee at the city planners department tells you. So when you come back and explain to your client, you're giving out false information. Or two, you may come back with the proper information, relay that to your buyer. They may misinterpret it. And again, that creates a problem. You can go down to the city planners department if you're talking about permits with your client, but make sure your client is asking the questions and that the answers are going to the client so that they are making their own determination as to what the meeting is and how they wish to proceed from there. So again, please do not go out and do the investigation for your client. Have the client do it, or at the very least, you go with your client, but make sure your client's there. Call your broker. Please don't be afraid to call us. When a situation first arrives, I've been lucky the last, actually pretty much all year, most of my agents will call me and we'll brainstorm on a situation that's coming up and I'll give input. That's what you want to do. Brainstorm. It's, even if the situation hasn't come up, but you're afraid it might, that way, if you call your broker, brainstorm on it, you'll be prepared to answer the questions as to, and the proper way to answer the questions when your client proposes them. So again, talk to your broker, call your broker, and make them a part of your education and roadmap on how to get through situations. Obviously, all agents, please be safe when showing property. If you get a feeling that doesn't seem quite right, make sure somebody goes with you to preview a house with a client. If the client doesn't seem right, don't just meet them there alone. Make sure there's somebody there with you to help you be safe. Be safe at all costs. Jeff, that's what I have for now. I have a few more things, but I'm going to turn it over to you to let you babble on here for a little bit. So Jeff Green, the stage is yours.
Yeah, one of the biggest mistakes that I've heard agents talk about lately is Tom Bullock's golf score. A lot of people were saying that he plays a pretty good game of golf, and I just want to dispel that myth right now in front of everybody. So, you have anything to add to that, Tom?
Well, yes. I'm.
Thank you very much. Okay, so what we're going to talk about, I want to talk about. And by the way, thank you for all your comments on there. They were good and very valid, and something that we all should take to heart. So let's talk about a few more. I want to discuss with you the bookends of your transaction, the beginning and the end. On the beginning of your transaction is the preliminary title report. Now, a lot of agents just get that, chuck it in the file, never think about it. Read that. Read the exceptions to title insurance and read anything that seems odd, and talk to the title officer and ask them specifically, hey, is there anything on here that I should be concerned about, or my client should be concerned about? When you find issues of concern, do not explain them to your client. Set up a conversation with the title officer to explain those. That's not your job. We are not title experts. The other extreme bookend of the transaction is your settlement statement. Now, everybody should be getting an estimated settlement statement. You should read those. You should make sure you understand what's on there. You should understand the fees, if there's anything that's strange, that doesn't look normal, credits for closing costs, maybe those they got left off, or perhaps there is a commission that's not correct. So make sure you read those. Don't just chuck them in the file and not think about them and figure out it's going to be okay. So it's not going to be okay. So years ago, there was a lawsuit and a legal case in 1984, Easton versus Strasburger. And most of us probably remember hearing about that, but it was so long ago that we probably forgot what it was. But it's basically broker liability. And what the situation is with regards to broker liability is, and when we say broker liability, we don't just mean the broker, Tom Bullock, sitting on his easy chair. We mean everybody. You are a sub-agent of the broker, so you have this liability. And most agents think that they're liable for what they know. And that's true. You're liable for what you know. But you're also liable for what you should know. So if you want to know the story of Easton versus Strasburger, both agents got nailed on it because they should have known that the house was constructed in an area where there was landslides, and they should have advised the buyer to do an investigation. They did not, and subsequently there was a landslide on a house in a very expensive part of the Bay Area, and that house value went down to $20,000. So both brokers got nailed on that one, and the seller did too. So always make sure that you disclose what you know and disclose what you don't know that should be investigated. And a good way to do that is to state it in an email. You know, I'm concerned about such and such. I haven't done an investigation on it, which tells them that that's not your job. You should, if you have concerns, you should investigate this. Hire an inspector, hire an attorney, whatever the nature of that investigation is. So let's talk about a few other items. Client stays over without a seller license to remain in possession addendum, or without a residential lease after sale. That would be even worse because they're staying longer than 29 days. If somebody stays for 1 day after the close of escrow, you guys need to execute an SIP. That spells out not all the legal, but many of the legal concerns with regards to staying over, like who's paying for the utilities, insurance, is there a deposit, the fact that the seller is supposed to leave the property in the same condition, and a number of other things. If you don't understand the SIP form, talk to your broker. Super, super, super important. And also super important, don't use an SIP for a stay over that's longer than 29 days. It says it right on the top of the form. The RLAS, the residential lease after sale, is a little bit more complicated than the SIP. It's like several pages. The SIP is 1 page, and it triggers tenant rights. And it's best to have a 1 day. If they want 30 days, it's better to have the escrow last 1 day longer and just do 29 days. Another issue that I want to bring up, and this comes up very seldom, but when it does, it's a biggie, and that is taking custody of funds. You are never to take custody of funds. We don't allow it in this company, and it's because we don't have a trust account. So the buyer makes an offer, they give you a check. Hey, could you give this to the title company or escrow company in Southern California? The answer is no. You have to deliver it directly. You can mail it, wire it, whatever, but it has to go straight to the escrow. We're not allowed to touch it. Escrow closes, your seller says, hey, I agreed to pay for the lawn service for the next month. I'm going to be out of town. Here's a check for the lawn service guy. Can you give it to him? The answer is no, you can't. So no handling of money whatsoever. It can't be done. A couple of quick other things, and these are not that common. Making disclosures called for, or missing disclosures called for on residential income or commercial purchase agreements. Both of those contracts have a list of disclosures that are agreed to by the parties. And some people say, well, there are no permits that were pulled. There's no this, but it's never removed from the contract. Best practice is if there's something on there like government retrofit issues or something that's called or listed in those disclosures section, we have a folder for it. It's a waiver of disclosures not provided or something like that. Just have the parties waive that, because you don't want it to show up later that something was there and you didn't deliver it. So if you have questions on that, speak with your broker. And then the final one is not discussing all possible inspections with clients. So years ago, I had a deal that was about to close, and I looked at it, and it was a house built in the 60s, and it had an original wood shake roof. There was no BIW in the folder to waive the roof inspection. There was no roof inspection. I called the agent immediately. I said, advise your client that they have the option to have a roof inspection, and if they don't, they need to waive it. And it's your professional advice that they should have it inspected, especially when it's a wood shake roof that's, older than Tom. I mean, it was ancient. So it's very, very important to have those wood shake roofs, things like that. Or what if you have a house with a chimney and it's you can see it's a brick chimney. You walk out there, the house is built in the 60s. They should have it inspected. That could be a fire hazard. Houses with pools, those should be inspected. You should encourage your clients to do all inspections, roof, pest, everything, general home inspection, and talk about it. This is part of why we get paid commissions, is because we are advising our clients on very important matters. So when you get into escrow, discuss these things. Say, here's your options. My suggestion is have a list of inspectors, not your favorite inspectors. Here's a list of 3 pest inspectors, roof inspectors, 3 roof inspectors, 3 home inspectors. Here's a list here with a little description maybe of what they do, and choose what you want, or I can give you some information about those different people, but don't just have your favorite inspector and use them on every deal. That could look like you've got a bro deal with the inspector. So that's what I have for now, Tom. I could give you a lot more, but I think those are some top ones that are there, other than your golf score. And I know that we're, just for clarity for everybody here, we're not talking about a regular golf game. We're talking about miniature golf, where you knock the ball into where the windmill trap is, or there's a dinosaur with a big mouth, and you roll that ball in there and it comes out somewhere down 20 feet down in another section. So that's Tom's golf game. And I'm handing it back to you, Tom.
Thank you, Jeff, and for all your words of wisdom there, and personal comments, I might say, were really enjoyable. One of the reasons that Jeff is so knowledgeable about 1984 was that was the year he started collecting Social Security. So it just was a good year for him, and he remembers everything about that year.
Thank you, Tom. Thank you.
And we like to keep him around just as a relic, if nothing else. Just a couple more things I have, and then we can sign off. But one of the things I noticed in reviewing RPAs is that on page 10, agents typically do not get the seller to initial that they were presented with the offer. That should be a good habit for all of us. And most of the time the opposite side may not challenge us on it, but if it ever happens, and I have seen that happen a number of times, you want to make sure that if you have that offer was presented and the seller's initial in the box, if the other side challenges you, you can just make a copy of it, send it over to the other broker or the other agent, and you'll be fine. If the seller rejects the offer, have them initial that too, if there's no counter offer. So just, I would get into practice of just having at least that fact that you presented the offer to the seller, have an initial off on it. You've already going through the offer with them anyway, whether there's a counter, whether it's a rejection, just get them that if the offer was presented and that the seller did see that. Follow through. Just make sure that if the buyer and seller come to an agreement, for example, if they come to an agreement on a request for repairs, and no repairs are going to be done, but there's going to be a credit, make sure that once that agreement between the buyer and the seller comes, that you get that information to escrow or to title, whatever you're working with. And the reason for that is the potential problem with a credit, any cash credit for any reason, could be a problem with a lender. And unless you get that right in and make that determination up front, you don't want to get to the end of escrow and find out that the lender knows nothing about it and will not approve it. Then you have a big dilemma on your hands, and you can't follow through with it because, again, if the lender says no, it's lender fraud if you follow through with it. So please do your follow through, do your due diligence, and if the agreement happens, get it into escrow immediately. Make sure the buyer side notifies their lender that they're getting a credit for X amount, and all will be good. That's really what I have now for this presentation. Any of my agents that are on the call, if you'd like to give me a call, if you have any specific questions regarding anything we've covered here, whether Jeff did or I did, I'll be more than happy to answer whatever questions you may have. Jeff, thank you. Tori, thank you. I appreciate you. And goodbye, everyone.
Perfect. Well, thank you everyone for joining us on this month's California Brokers Business Accelerator. And of course, like Tom said, if you have any questions at any time, you can always email or call your brokers. That's what they're there for. They are there to answer your questions. Thank you to Tom and Jeff for all of your wonderful insight. And of course, a special thank you to Tom for leading today's topic and presentation. Thanks again to everyone for joining us, and I hope you all have a wonderful week. Bye, everyone.
Goodbye.